Is it that, it is chilly today? Is it that time of the semester? Yeah, yeah. How are you feeling about the sentencing submissions coming up? Yeah, you have totally got it right. You have prepared really well for it. You've had your feedback on your submissions. Some of you have done the amended submissions. The judges completely understand what it's like to have to stand up and give a sentencing submission. So in my experiences, most students I've ever taught will be feeling just like you did when before it, but actually by the time they've done it, they feel quite excited about that they did it, you know, that it was quite, there's a lot of adrenaline rushing around at the beginning, but once they get into it and they start to get into their stride and they're answering questions, they end up really enjoying having done that process. So it's okay and quite usual to feel a sense of slight apprehension about something. It's a different form of assessment than to what some of you will have done before, but also try and grab those nerves and run with them and use them in a positive way to keep you focused, to get you excited, to speak in a way that shows your interest in your client, okay, and what you're trying to argue and mitigate for them, okay? So there's lots of positive. It's got quite a nice feeling because it's done in the evening, so you're in there with other students, so there's a bit of a buzz going around. Everyone, some of the ones that are doing it early will have come out and then you're going in, so you've got lots of it's a nice cohort building feeling, right? You get to meet other people doing the same thing, okay? So try and be okay to feel apprehensive and then go through with those nerves and you'll be great. The other thing to say is that Lucy's got office hours now between 3 and 5 o'clock this afternoon over an 8-10 in her office. So if any of you have got any queries about the oral sentencing submission, I know she's got those 2 hours of office hours this afternoon. If you think you have got queries, I'd definitely go now and do it early and get that advice now. The other thing, rather than leaving it till next week where she's busy with running the whole sentencing submission all week. The other thing to say is that make sure, if you haven't done already, Lucy has prepared a really detailed, helpful guide around preparing for and presenting your oral sentencing submission. Have you seen it? It's up on Canvas on the modules tab for the sentencing assessment. So if you haven't looked at it, please read it. It answers lots of the more sort of straightforward, frequently asked questions, but has lots of really helpful tips about how to address the judge and how to kind of turn your written submission into your oral one, and how to get familiar with the content and how to advocate in a really positive way. So engage with engage with her written document on preparing for that oral sentencing submission. Okay. What we're going to do today is have a chance to practice what we've been learning about for the last couple of weeks. So on Tuesday, we finished off looking at the offence of sexual violation, and then we also looked at indecent assault. So as I mentioned to you the week before, there are lots of different sexual offences within the Crimes Act, and we look at 2 of them, sexual violation and indecent assault. Okay, so you'll see your textbook that Julia led on has a number of other different offences. The 2 that are part of our syllabus for this year are sexual violation and indecent assault. They're the 2 we're focusing on this year. Okay, so we're going to have a couple of fact patterns that are going to give us a chance to practice what we've learnt. Again, work in groups if you would like to. If you're sitting on your own and you want to join a group, feel free to move around. I'm sure your colleagues would be very happy for you to join their group. If you would prefer to work through it on your own, then that's perfectly okay too. Remember, as I keep saying all the time, these are your spaces. So if you've got, this is the time to ask questions, this is the time to give things a go. It's okay to get stuff wrong. That's actually how we learn, okay? So feel free to contribute. Try not to be apprehensive of talking and contributing, right? Because it's a great learning environment. If you've got any questions while you're working through the problem question, just let me know and I can come around to the different groups. So let's start with our first fact pattern. We've got Kevin and Matt. So they're at a nightclub. Let's just, for the purposes of this pattern, Kevin hasn't been drinking this particular evening. So he sees Matt, a guy he works with. He doesn't really like Matt. He thinks that Matt takes work too seriously, doesn't seem to want to have a good time at work. So later in the evening at some point, he goes over and starts chatting to Matt, and they start talking. And then, thinking it's going to be really funny, as Kevin is leaving the conversation, he brushes his hand up against Matt's trousers, touching Matt's genitals. Matt tells him to get off, and then Kevin just laughs and just heads home thinking no more of it. What I'd like you to work through now is whether you think Kevin has committed any criminal offences. So first of all, in your groups, think about what offences that you could possibly charge Kevin with in relation to this behaviour. And then isolated, work out what are our actus reus, what are our mens rea elements, and then apply those legal elements to the fact pattern in front of you. We have about 10 minutes to working through this fact pattern, and then we'll come back in terms of the big group and work it through as a group. Okay, so if you want to start. Okay, have a couple of minutes and then we'll come back. Okay, if we come back now to the bigger group. So what offences did you identify that you could potentially run an argument with in relation to Kevin? Which ones did you look at in your groups? Yeah. Yep, can you remember the statutory provision? Anybody want to jump in? Yep, 135. Brilliant. Indecent assault under 135. If it wasn't indecent assault, what else could it be? Yeah, just normal common assault, right? And do you remember? Statutory provision? 196, perfect, right? Now, they're not going to run both, right? They're going to go for indecent assault. But just because the directions say, has he committed any criminal offence, because we know assault is at the heart of an indecent assault, then obviously if that element of indecency for some reason couldn't be proven, you have at least got a common assault, okay? So let's focus though on the one that's the most likely one to run, which is a section 135, this indecent assault. Okay, it's a much more serious offence, isn't it? We know it's up to 7 years imprisonment as opposed to common assault, which is up to a year. So what are our elements of an indecent assault? Yeah.
Assault and an element of indecency.
Good. So we have to first find the assault and then look at this notion of this element of indecency. Perfect. Has he committed an assault? Yep, good. How do we know that? What is our law? How would we apply it? Yeah?
Potential application of force to that, without consent.
Yeah, good. So where do we find that definition of what an assault is? What's the statutory provision? Good, section 2. Excellent, right. And as you picked up, the actus reus is the application of force, in this case direct application of force because his hand has brushed the trousers on the genital area. Does it matter that when we talk about application of force, does it need to involve violence or anything like that? No. We know that mere touching can be enough to constitute the application of force. Okay, that suffices. So run with a different scenario. What would happen if, I don't know, say Kevin's mate standing next to Kevin and Kevin grabs his friend's arm or something and gets the friend's hands to run up against the trousers of Matt on the genital area. Does it matter that it's not Kevin doing the touching? In this case, he's using someone else's. No. Why does it not matter? Yeah, because it's direct or indirect. Fantastic. So we know that what we call innocent objects, right, which would be the friend's hand in that case, right? We know that you can use, it would be the same as, I don't know, say he's got a cap on or something and takes the cap off his head and using his cap, he brushes it past, okay, the guy's genitals. The cap can be the object That's the indirect application of force. Okay? Brilliant. So we've got direct, in this case, a direct application of force to the person of another. What's the mens rea for an assault? Intention. Perfect. Right? Okay, so it's intentional. Do you think it was intentional? Yeah, why do you think it was intentional?
As he says, thinking it would be funny in reference to the action he takes.
Yeah.
It shows that he's thinking about what he's going to do, doing it for that purpose.
Yep, doing it deliberately for that purposefully. Yep, it's his aim. Why else is that phrase about thinking it's going to be funny might be relevant? What else might that speak to?
Mens rea, like thinking it's going to be degrading or
Yeah.
amusing for other people that he does it.
Yeah. And the reason that that's important to raise is that we're very clear with indecent assault in this country, and actually sexual violation as well, that it doesn't matter what the motive is, right? There's a difference, isn't there, between motive and the mens rea, which is the intention. So even if he just says to, say he's your client, and he goes, I wasn't trying to be getting off on it, it wasn't really kind of sexual motive, I just thought it would be a laugh, the guy's so uptight, I thought it would, just was going to be funny. That doesn't matter, right? That's his motive. It's irrelevant, right? And we know for in New Zealand, for these sexual offences, they don't need to prove, as the prosecution, any kind of sexual motive, right? So why he's doing it is irrelevant, okay? Other than building up that he intended to do that application of force to the person of another. You said without consent. Is there any? Why is consent something you want to think about in relation to this offence? Yeah, perfect, right? So this is the other really important thing is when you're dealing with indecent assault, because the assault is at the heart of it, and assault, remember, is one of those interpersonal violence offences that we looked at in previous weeks. And we know, don't we, as you've just pointed out, that when you're thinking about consent for an interpersonal violence offence that's non-sexual, non-fatal, it works as a defence. Now, as I mentioned to you on Tuesday, the Crown don't have to discharge any kind of onus around consent unless it's raised on the evidence. Do you think there's any issue of consent that you could be raising on the evidence here? No. It's very clear that Matt's not consenting. But a different fact pattern, there might be something in there that, if you imagine you're the defence, could be saying, well, my client says the person consented, and importantly, remember with victim consent, we say, did the defendant have an honest, genuine belief? Even if it's mistaken, even if it's unreasonable, it's an honest, genuine belief in the consent. So you're quite right, it's not raised on this fact pattern, but on a different fact pattern when you're looking at indecent assault, when you're still dealing with the assault element, see if you can find any evidence around a defence of victim consent, okay? And if it's there, then put it into issue and deal with it by going, did the complainant consent, and did the defendant have an honest, genuine belief in that person's consent? But as you say, it's not relevant here. So we've got an assault, we've got intentional application of force to the person of another. Brilliant. What about this element of indecency? How do we work out whether something is indecent or not? What's going to change this from being an ordinary assault to an indecent assault?
In the case of, I believe it was King Dunn, the Court of Appeal said that the aspect of indecency must be judged in the light of time, place, and circumstances. And in this case, contact to the genital areas is considered to be indecent. It's not something you would naturally do with an individual that you didn't have prior consent for, very easily.
Yeah, absolutely. If you didn't have consent to do it. Yeah, absolutely. So, and then remember, it's the Queen. It's the Queen and Dunn. So just only picking it up because you've got your sentencing submission coming out. You know? So if it's pre the Queen dying, so while our Queen, if it was decided when the Queen was still alive, it will be the Queen and Dunn, which is that case. If it's since then, so post that September 2022, then it becomes the King and whatever the name of the case is. Okay. Yeah?
That's so annoying.
I wondered why you were shaking your head.
I know, I just think it's annoying. Like, you see 2022, you just have to immediately go, uh-oh. Like,
Yeah. Okay, good. So you're right. So the Queen and Dunn talks about time, place, circumstances. There was that Peters and Police, the High Court case I talked you through, which was also, and I think it was like nearly 20 years old, isn't it? 2007, I think. Why is that relevant? What principle is that talking about?
So contemporary norms are relevant in determining what is or isn't
Yeah.
decent.
Yeah. And I imagine our norms have changed, right, from why the judge was talking back in those days. But it stands for that idea, a bit like your time, place, circumstance, that when you're trying to work out if something is indecent or not, you're talking about what's contemporary norms at the time. So you take ordinary meanings. The Queen and Nazif talked about taking ordinary understandings or meanings of what it means to be indecent. Whose decision is it? Jury, right? Question of fact for the jury. And did you pick up in the cases how they talk about trying to work out this element of indecency? What is the language they use around it? Yeah? Yeah, so either right-minded members of the community or right-thinking members of the community. Good. Okay, excellent. I think you're right, given the area of the body that the application is forced in. I think you're right, there's an element of indecency in terms of the physical application of force to the person of another. What about the mens rea? We know we've already got the mens rea for the assault because we've said it was an intentional application of force to the person of another. But do we have any additional mens rea in relation to the indecent assault?
well, there has to do something indecent, but I'll note it's not necessary that the accused knew that there was an element of indecency, but it is relevant whether the jury thinks that the act itself is indecent.
Yeah, perfect. Great explanation, right? So it's the intent to do something indecent, which means that the jury thinks that that act is an indecent one, and then you can show there was an intent to do that act, right? So here we're going to say the jury would assume that touching someone's genitals, even over clothing, is an indecent act, and therefore Kevin had the intent to do that indecent act. Perfect. And actually a good case to have a look at on this is the case of Elwyn, right, where the Court of Appeal are talking through those kind of elements of talking about what the Crown has to prove. So it's that the assault happens, so the deliberate application of force to the person of another, although note in that wording, it would also apply to those other ways of doing an assault under Section 2. The assault occurred in those circumstances of indecency, which is that other part of the actus reus, right, that we've talked about. And that, as you say, the accused intended that act and that the jury thought that that act was indecent, right? Does the only kind of thing to think about that we've had some kind of issue, I guess, in cases that were fairly close together in the High Court, the Court of Appeal, was whether there's this kind of third element of mens rea, which is like, do the prosecution have to be able to prove that the accused knew that other people thought it was indecent, or at least recognised that the jury would find their behaviour, or the right-minded people would find their behaviour indecent? Can you see it would make it much harder to prove, wouldn't it, of the prosecution, if you had to prove not only is someone intending to do an act that other people find indecent, but actually you're having to prove that the defendant, when they intended the act, also recognised that those right-minded people would find it indecent. Because that would be subjective. You'd have to get into the head of the defendant to be able to prove it. That came up in a case of Armstrong, which was a case involving a younger guy in terms of he was 18. And he had put his hand up the skirt of a young girl of 14. And the argument that was run by the defence was that he didn't realise it wasn't consensual. He thought she was consenting. In fact, he paints a picture that she was wanting it to happen or she was initiating it. But another argument he ran in that was that he wouldn't have realised that other people would find what he did to be indecent. And so the Court of Appeal kind of bring in this third mens rea element. But Elwyn comes along, which is also Court of Appeal.
Yeah, I was going to say, if I'm reading the case numbers right, Alwyn is afterwards.
Yep.
So kind of
That's it.
contradicts that.
Yeah.
Sets it aside.
Yeah, perfect. So go with Alwyn, right? Alwyn makes it clear that there is no third mens rea element, right? You just have to prove as the prosecution someone intended to do the application of force, which is the assault. You then have to be able to prove they intended the act which was considered indecent by others, but you don't have to prove that Armstrong element, right? Alwyn makes it really clear because it comes after Armstrong. Alwyn says you don't have to prove that the defendant recognised themselves that right-minded people would think it indecent. Can you see the distinction? So just to recap, what's our mens rea? The mens rea for assault.
Intention.
Yep, intentional application of force, and the mens rea bit for the indecent. What's the mens rea bit for the indecent part? Yep.
Right thinking members of the community would think it's indecent, and then that the accused intended to do the act,
Yeah.
which they then consider indecent.
Yeah, good. So the accused intends to do an act that other people or right-minded people would find to be indecent. We know from Alwyn, from the Court of Appeal in Alwyn, there is no requirement that the defendant, him or herself, had to recognise that other people would find that indecent. Does everyone get that distinction? Yeah? Good. Okay, excellent. Because it's probably the only bit where there's some sort of issue. But I think, as you say, Alwyn is a Court of Appeal case, similar level, comes after the Armstrong, so I think we go with Alwyn, okay, as the taking the ratio forward.
Surprised that hasn't come up in like nearly 20 years.
Yeah, yeah. Thing about a small jurisdiction. Takes a while, doesn't it, for stuff to come up to the Supreme Court to get a definitive on it. But I think, given, as you say, that Alwyn comes after Armstrong, I think we can be confident that we don't have that third kind of mens rea, right? Okay, let's have a look then at the second fact pattern. In this case, we're dealing with the offence of sexual violation. Here we've got two people who are in their 20s, Rob and Claire. They meet at a party. They are getting on. They spend the evening talking and having a drink. Later that night, Claire invites Rob back to her flat. Now, according to Claire, she says she felt pressurised into engaging in sexual activity with Rob and repeatedly said no to him and tried to push him away. She also says that Rob ignored those objections and proceeded to have sexual intercourse with her. Rob claims that Claire never explicitly refused consent and said he believed that she was consenting based on her body language and also that she'd been flirting with him through the course of the evening. Rob also states that Claire doesn't resist physically, so she doesn't resist physically and she doesn't say stop at any point when they're having sexual intercourse. So probably in about 5-7 minutes, we'll see how we go. If you in your smaller groups work through again the offence of sexual violation in terms of the actus reus and then in terms of the mens rea, and then apply that to the facts, and then we'll come back into the bigger group and talk about it. Okay, so have probably about 5 minutes just to nut out the actus reus, mens rea with some application, and then we'll come back together and talk it through. Okay, should we come back into the main group? Where do we find in the Crimes Act, where do we find the offence of sexual violation? What's the statutory provision? Brilliant. So section 128 capital B is the one that sets up the offence of sexual violation and tells us it's punishable for up to 20 years in prison, right? So that creates the offence. Then we've got the sexual violation in 128 subsection 1 has these A and B, doesn't it? So it tells us that sexual violation is either rape or it's unlawful sexual connection. What is it in this case? What kind of behaviour are we looking at here in terms of the type, I suppose, of sexual violation? Rape. Why is that?
Because it was non-consensual intercourse as opposed to just, because with sexual connection, it's more of, right, hold on, I'm trying to find it. Yeah, because rape is penetration, sexual connection isn't.
Yeah. So rape has a very specific gendered meaning, doesn't it? Where it's talking about the penetration of a genitalia by a penis. Unlawful sexual connection is a much broader definition. It also can cover the introduction of, so it could be this kind of scenario, but it captures a wider range of sexual behaviour, right? So rape has this very gendered, talking about the penetration of genitalia by a penis, right? So in this case, it's coming under the 128 subsection 1 paragraph A. Where do we go to find the elements that define rape? Anyone pick it up? 128. What's this? Yeah, perfect. Subsection 2. Now this is the defining, right? This defines what rape is. 128 capital B is the one that creates the offence. This is super important for those of you who are around when I gave some feedback on Tuesday on the test. Make sure that as you go through the semester, you become really clear about which of the offences are the ones that create an offence, which are the ones that set up like a duty, which are the ones that define the elements of an offence, which are the ones that set a standard, like, for example, your 150 capital A in terms of major departure if you're assessing the standard, okay? So it was one of the things we picked up in the test is some people talking about, say, a legal duty and saying that's where the offence is created. So just understanding that in the Crimes Act, different statutory provisions do different things, okay? So that was a bit of a departing from the sexual violation, but the offence is created in the 128 capital B, and then we get the defining elements, the actus reus mens rea, within the subsection 2. So, what's the actus reus then for rape? Yep, so this is the behaviour itself, yep, so the penetration of the genitalia by someone else's penis, great, that's one of the aspects of the actus reus. What's the other bit?
One of the two parties does not consent.
Good, so there is the issue of consent is also in the actus reus, right? One of the parties does not consent. It's a really important thing to pick up in terms of sexual violation, that consent operates in the offence, and it's part of the actus reus, and it's also part of the mens rea. That's a really important distinction from indecent assault that we've just been looking at, where consent, if it's raised on the facts, will come into it as a defence. Okay, that's one of the things that we're often testing on. Do you understand the difference in how consent works as to whether it's part of the offence for sexual violation or part of the defence for something like indecent assault? Because at the heart of indecent assault is the assault. Okay, so let's go back then. We've got our actus reus, which is the behaviour, the penetration of the genitalia with the penis, and this issue of does someone in fact not consent? Yeah, perfect. What about the mens rea for rape? What's our mens rea?
The accused does not believe that the other party consents, or if the accused does believe that the other party consents, there's no reasonable grounds.
Perfect. So we know that from 1985 onwards, we added in this reasonable grounds, right, to bring in a more objective understanding. So either the prosecution Well, the prosecution will first start with seeing, is there any evidence that the accused doesn't believe that the other party consented? That's the first thing that they'll look at. Often there isn't that evidence because, unlike our case, where Rob is saying, well, she was consenting, right? I believe she was consenting. So then we're into the second scenario, aren't they? That even though Matt is believing in her consent, whether there are reasonable grounds or not for that belief. So the prosecution is going to have to prove that there are, beyond reasonable doubt, no reasonable grounds for a belief in her consent. How do they work that out? How do we decide whether or not there are reasonable grounds for a belief in consent? Can you remember any of the cases that might be relevant? Yeah. Perfect, right? Excellent. So the Queen and Clark, which was then put by the case of Mustafa Khan, so Queen and Khan, which was a Court of Appeal case, adopted what Clark had said several years earlier. And then the case of Queen and Tanafa, which came later, which was a Supreme Court case, again adopted the line of reasoning from Clark and from Khan. Absolutely. You take your reasonable person and you put them in the shoes of the defendant. That's really important. And the other super important thing you said is that that reasonable person is always sober. And that's relevant because in our fact pattern, Matt's been drinking. Rob has been drinking. So his drinking has got no relevance to that assessment of reasonable grounds for a belief in the consent. And that came out of that case of Queen and Clark really clearly, because in that case involving the 3 adult men with the 16-year-old girl that they raped, they tried to run an argument that they'd been drinking so much. That's why they had a belief in her consent. And if we had just gone, okay, what does the accused believe, and then is that reasonable? That is not going to bring in this, the Queen and Clark, the judges said, that doesn't bring us close enough to the intention of Parliament to bring in an objective test to this standard, right? And so they talk about in the Queen and Clark about, it's not about going, what did the accused think and was that reasonable to hold? It's about going, hang on, here's this reasonable person who's sober. So suddenly the men's drinking in Clark makes no difference, right, to that assessment. So we take the reasonable person who's sober and we put them in the shoes of the defendant. Okay. So now applying it to our fact pattern. In terms of the actus reus, they have had sexual intercourse, so we've got the penetration of genitalia with the penis. We've got the first part then of the actus reus. Has she in fact consented? What are some of the factors that you're pulling from the fact pattern to come to a determination?
She pushed him away and said no.
Mm-hmm.
Having said that, though, Rob claims that she never explicitly refused. But having said that, he also said that based on her body language and prior flirtation, which cannot be used as an indication of consent, because just because you're not coming back does not mean consent.
Yeah, great, good. So using the fact patterns to... So in her perception of it, it's very clear she has not consented, in fact, right? She said no, she's pushed him away. But even in his perception of it, from what he's telling us, there's enough in there, isn't it, that he's saying? Yeah, perfect, right? So section 128, capital A, subsection 1. Remember, 128, capital A is where we set out all those different actus reus parts of where you cannot, in fact, consent, all those matters. Well, the subsection 1, as you said, is saying that a person is not consenting just because they're not resisting. Right? So that the wording in here where it says that he says that she wasn't physically resisting and she's not saying stop and things is to get you to engage with the 128 capital A subsection 1. Is that prior flirtation and body language relevant? No, right? Doesn't matter if the entire day or the entire party she's been explicitly saying, I want to have sex with you. at the moment that the penetration happens is when we talk about consent, right? And on the facts, it's clear that she has not been consenting at that point in time. And then in addition to that, there's the 128 capital A subsection 1 that makes it really clear that she hasn't been consenting just because she's not resisting. In that case of Christian that we've looked at in the lecture, the Supreme Court were having to look at whether or not there was like, how do you work out whether someone in fact has consented or not? And they utilise or engage section 128 capital A subsection 1, and they draw attention to the fact that the statute says that just you are not consenting just because you're passive, right? Just because you're not resisting. They reject the idea of a need for a positive kind of affirmation of consent. So I think it's great that you've picked up the 128 capital A subsection 1. What about the mens rea? So I agree, I don't think she has in fact consented. What about the mens rea? Are we going to be able to, as prosecution, prove beyond reasonable doubt that he didn't believe in her consent? No, because he's going to say, I believe she was consenting, right? So in terms of our mens rea, we're going to be concentrating as a prosecution around this part, the second part, right? That even though he says he had a belief in her consent, there are no reasonable grounds for that belief. That's what we're going to be proving beyond reasonable doubt. What are some of the things that we're going to talk about in our analysis around whether or not the reasonable person who's sober in the defendant's shoes? How are we going to talk about this reasonable grounds for belief in her consent from a mens rea proof? That case of Christian's really important, Christian and the Queen, because the Supreme Court were exactly looking at section 128 capital A subsection 1. And what they said in that case is that where there is, in fact, someone has not consented just because they were not protesting or resisting, you cannot then, as a defendant, run a line of argument about a reasonable belief on that basis. Perfect, right? There must be something more in the words used, the conduct, the circumstances. Now, in Christian, it was a very different fact pattern. So it was dealing with a much older guy with a much younger girl in her teenage years, that he had been having sexual intercourse with her over a course of a number of years. And they talk in Christian on the point of law that you need to find other circumstances if you're going to try and infer a belief in consent. And they said that those other circumstances could be things like an expectation of a relationship, so relationship expectations. But that it's not relevant here, right? Because these people are not in a relationship. Is there anything else on the fact pattern that we could try and find a reasonable grounds for belief in consent in terms of what happens between Rob and Claire? So the really key thing to pick up on this part of the mens rea inquiry is Christian is a super important case to read. Okay, so out of all the cases, all the cases on your reading list are important, but the one that's super important is the case of Christian, right? Because they talk directly about that interrelationship between section 128 capital A and the mens rea. Remembering the 128 capital A is about the actus reus. What then does the actus reus do to this mens rea? And they say it does have a relationship. The majority judges said that there is a relationship. It does bear on that 128 capital A. But and specifically when talking about subsection 1, where someone is not consenting just because they're not protesting, they make that really clear in Christian that if it is that someone has not consented, in fact, because they weren't resisting. You then can't run a line of argument as a defendant purely on that basis alone of the passivity, right? She was passive, she was not resisting, therefore I believe she was consenting. They were really clear, you can't make the inference just on that alone. As you pointed out, you have to find something else in the words or the circumstances. Now, in Christian, they did try and say, potentially there could be something else around these relationship expectations, even though they said there's no way a jury really would ever buy that argument, right, when it goes to retrial. But here in this case, I don't think there's even that kind of argument to run. So he's not going to be able to be successful with running this reasonable grounds for belief. So I think as if we're prosecuting him, I think we can prove that he didn't have reasonable grounds for a belief in her consent. I just want to say a big thank you for the way that you've engaged with this topic. I know that it's a difficult topic to engage with and can be really quite confronting, and sometimes can be confronting even when we're not expecting it to be confronting. So thank you for the way that you've attended and been engaging in the lectures in such a respectful and mature way, and likewise in the workshops. Next week we start looking at defences. So we now move from sexual offences and we start looking at a topic of defences. I'll start you off it. So next week is our last week before the midterm break. So I will start you off at looking at self-defence. So for anyone, she says optimistically, given you've got a sentencing submission coming up, but if anyone is reading ahead, then it's self-defence we're focusing on next week. If not, try and enjoy as much as you can your sentencing submission. I look forward to seeing you next week in the evenings as well for your sentencing submission. Good luck if you're on Monday, and have it before I get to see you on Tuesday. Okay, take care and we'll see you next week. Sorry, Vernon.
Sorry, but I need to just check something quickly.
I'm just going to pack up because Vernon's about to start teaching, but if you just wait outside, I'll come and talk to you. Hi, sorry.
How's it going?
Good, thank you. How are you doing?
Yeah, not so bad. What have you been teaching?
Sexual offences. In criminal law. What are you about to teach?
Resource management.
Right, different.
Very different.
Very different. Thanks very much. Thank you, see you next week. Close all that down.